Appellant was concerned that the courtroom is extremely hot. It is. I probably get used to it because my children was describing it as the lizard. I won't elaborate on that. But I mean, if you are too hot, but for goodness sake, take your wigs off. We'd be very happy for you to take your wigs off. All of you, that means, not just the people who's on. If you want to keep it on, that's fine. But okay. Right. Yes.
My lords, Mr. Connelly went through both the decision and through some features of the market that he said rendered the case intrinsically weak. And I want to run through some of those. I do so, of course, in the context in which I take it, you'll take it as read that I stand entirely by my submissions that it is not the correct approach to look at the weakness of a case.
Yeah, I understand.
Provided, of course, that I do accept that the court is entitled to consider whether the summary judgment threshold is passed, provided, of course, a proper procedure is followed. So the first point that my learned friend made at various points was, I think, the low numbers of the actual traders involved, and 9 of them. But it is important also to appreciate their seniority. And with that in mind, could I hand up a letter that we sent to the CAT during the hearing that gives some publicly available information, albeit that this letter is confidential, about the identity of the particular traders involved, because it is important to bear in mind just how senior a number of these individuals were. I think in terms of filings, we've given this that it can be put at the back of the third supplemental.
Should we read this to ourselves?
Yes, I think that would be.
Does their seniority carry greater gravitas in the marketplace? What's
It allows them to control the relevant trading desks in our.
So it's not so much what they do in the marketplace, it's the ripple effect elsewhere in the trading room.
Yes. And it's no doubt on the basis of this sort of information that one sees, and you don't need to, I think, turn it up. You'll see for your note, paragraph 164 of the judgment, page 316, the tribunal says we are prepared to proceed on the assumption that the traders are assumed to be influential.
Yeah, where did you suggest we should put this letter?
At the back of the third supplemental bundle.
3.
My lord. Now, another feature of my learned friend's argument was that the exchanges are described, some of the exchanges on spreads in particular, are described as being occasional. And my Lord Justice Snowden rightly picked up the fact that when one looks at the footnotes, it's clear that by occasional they mean at the very least every month during the relevant period, because one sees examples given that are at least monthly. But it's also relevant to note that a number of the other types of collusive activity are described as being extensive and recurrent. And indeed, the collusive activity is described as being on an almost daily basis. Just for example, you'll find the words extensive and recurrent in recital 1, recitals 44 through to 46, 51 to 52. Now, Mr. Kennelly referred you, he said,
Which decision?
of both
Of both.
decisions. Mr. Kennelly referred you to the potential for small but pervasive effects. Well, pervasive we accept, but we don't accept that he's entitled to qualify them as necessarily small. Some of these this collusive activity might have had a very large effect. Oh, forgive me, persistent. I'm told it was persistent. Well, persistent we will take as well. But we don't accept that he's entitled necessarily to qualify the effect as small. It might have been a large effect. My learned friend also made much of the relatively low market shares of the cart lists, which he noted go down to the mid-30s. Now, this is a point, but not one that affects the overall theory. When you can consider, as I was seeking poorly to explain earlier, when you consider the two effects in combination. And perhaps I could just, to show you, to illustrate the point, could I ask you to go, please, to volume 3 of the supplemental funding, to paragraph 53. This is the third expert report of Professor Bernheim. And if I could invite you to go to page 3194 to start with, just to show the... And if you see paragraph 17, perhaps I could read it to you. He says, based on my reading of the EC decisions and the other materials provided to me to date, and pending any closer examination of the factual record, I take the mechanisms described in my previous report as the most plausible channels through which the cartels described in the EC decisions altered market outcomes. Professor Rime estimates that the market share of the 6 addressees of the EC decisions is less than 50%. So he acknowledges the market share point. Respondents argue in the joint CPO rejoinder that with market shares in this range, any simple attempt to widen spreads by cartel members would have been unsuccessful because it would have driven business to opportunistic rivals. That's precisely Mr. Kennelly's submission. He says, what Professor Ryan fails to appreciate is that the discussion of the adverse selection mechanism in my first report provides a compelling answer to that argument. While a relatively small cartel in terms of market share might have difficulty profiting from a naked coordinated price increase due to competition from non-colluding rivals, the same strategy may be highly effective if the cartel members can also coordinate on strategies that raise their rivals' costs. To the extent that they succeed in achieving the latter objective, they can collusively raise their own prices without fear of losing business to rivals on a scale that would make the collusive strategy unprofitable. As I explained in my first report, the magnification of rivals' adverse selection risks was important precisely because it raised rivals' costs of doing business and consequently provided the cartel members with latitude to widen spreads for their own customers. That's that combined effect that is why there is potency, notwithstanding the low market shares. And he expands on this later on in his report at page 3219. If I could invite you to look at that. And paragraph 85 on page 3219, he's now directly addressing the respondent's question. He says, first, the respondent's question whether collusion among respondents could create significant adverse selection risk. They point to limited market share accounted for by the individual participating traders, and the fact that adverse selection risk depends on a whole range of factors. Claim 1 concerning limited market share displays a poor understanding of adverse selection risk. To illustrate respondents' conceptual error, imagine first that under normal competitive conditions, a dealer has 10% share of the volume traded in a given currency pair and observes the order flow associated with that market share. The slice of order flow gives the dealer some insight into the state of the market and the likely direction of future FX rate movements. Now imagine that the dealer joins a cartel with a collective market share of 50%, whose members exchange information on order flow, thereby giving each member a window on the aggregate order flow associated with the cartel's collective 50% share of the market. As a result of this exchange, each cartel dealer becomes far better informed about market conditions and far better positioned to identify profitable trades with customers and non-cartel dealers. Rival dealers therefore face considerable greater adverse selection risk. Accordingly, for the purposes of evaluating the adverse selection mechanism by which cartel members raise rivals' costs, the relevant consideration is the size of the difference between the individual dealer's market share, here 10%, and the cartel's collective market share, here 50%, rather than simply the absolute size of the cartel's collective market share, as respondents' argument implies. So in other words, it's simply looking at low market shares is not an answer to the adverse selection risk effect, and it's then not also, as a result, not an answer to the collusion, because combined with the adverse selection risk, you then, even with a relatively low market share, the collusion can have effect. That's what I was trying to explain by reference previously, by talking about the combined effect. And that's what is alleged to be going on here. Now, Mr. Kennelly said on a different topic, he said, well, the trades that you focused on, the bid-ask spreads, those aren't really the core of the infringement findings. He said that's not about bid-ask spread at all. It's about benchmark manipulation of the FX benchmarks. He said that on page 111 of the transcript yesterday. Now, it is true that on the face of the Commission decisions, at least, the benchmark manipulation appears to be a larger focus of the traders' unlawful activities, but it's not by no means the only focus. The bid-ask spread is also there. And in any event, the O'Higgins methodology does capture the loss that flows from benchmark trades. And if I could ask you to turn up volume 2, please, of the supplemental bundle, where you see Professor Breeden's report at tab 39. This is his second report. And if I could invite you to go to 2712, please. He says, it says in 312, paragraph 312, he says, regardless of whether or not there was an explicit agreement, and I've not asserted in my amended first report that there was an explicit agreement, information regarding spreads was exchanged, which allowed the participants to adjust their own pricing. This may not necessarily have always resulted in a widening of the effective spread. Whether it did is an empirical question, which will be captured by my proposed approach. My realized half-spread methodology does not just capture the harm caused by any tacit or explicit effective spread widening agreement, but also captures the harm caused by mid-price manipulation, for example, collusive front-running before a benchmark fixing. Thus, I do not require effective spread widening to have occurred in order to be able to estimate the extent to which class members have been harmed.
Can you translate it to English? Collusive front-running before a benchmark fixing.
The fix is when...
We're talking about tacit or explicit collusion here.
I think here I think it's coordinated trading, so I think it is actually explicit collusion. They could conspire to basically place orders just before the fix when the market price is fixed, so as to push it up in one direction or push it down in another.
So front-running, the collusive front-running is coordinating the point at which you get into the market
in order to fix a benchmark.
Fix the benchmark.
The fix is the
on the assumption that people will then follow.
Yes. So the fix is essentially a type. It occurs at a particular time, and you will say, I will trade at whatever the fix is at that point. So by coordinating their trading, they can push up the fix or push down the fix. And Professor Breeden's point is by looking at the realized spread, and he and Professor Bernard have a rather complex explanation of how it would do this, but they can capture the effect of fixing these benchmarks. by looking at the realized spread, which is a slightly different measure from the effective spread. If one goes forward to 3.23 on page 2716,
Yeah.
see another point. It says the joint response argues that the Commission's findings in respect to the occasion exchange of information on bid-ask spreads concerning specific quotes to a particular client or to customers, not to dealers that were not party to the infringements. They state that the Commission didn't make any findings of anti-competitive conduct with respect to spreads on the inter-dealer market, being the market on which FX dealers trade directly with each other, and nor did it make any findings as to effects on that market. I have not seen the underlying chats and cannot confirm or deny whether there was collusion on spreads in the inter-dealer market. However, it is worth noting that as discussed below, collusive behaviour, for example, manipulating the fix, what we've just discussed, would have harmed participants in the inter-dealer market, even if their trades were not amongst those used to create an information advantage. So in other words, the activity that Mr. Kennelly said was at the heart of heart of the infringement, benchmark manipulation, would affect the inter-dealer market, which is how the adverse selection risk occurs. Now, my learned friend's the heart of his criticism.
Can you just identify in a sentence how that happens in the inter-dealer market? Just so I've got it. I mean, I understand the concept of saying to somebody, we'll trade at the fix at 4 o'clock, if that's when the fix takes place.
Yes.
Is that the sort of thing that goes on in the inter-dealer market?
It apparently it does affect, well, he's saying here that it does affect the inter-dealer market.
Yeah, but he says it does for reasons he explains below, and I just want you to give me a sentence telling what I would find if I went below, just so I understand.
Forgive me, yes. Let me, it's, I think it is, can I come back to you with a reference, because it will prevent me?
Well, it wasn't so much the reference, I just wanted you to just paraphrase what I would find when I get there, but if you need to go somewhere to...
I don't want to get it wrong.
Okay, all right. Fine, come back to it.
Yes. So the suggestion of Mr. Kennelly, and this is his, I think, the heart of his criticism of the adverse selection effect, is he sets up a requirement. He says, well, cartelists dealers would only be affected by it if they could detect and isolate their losses. That's what he said. And that is, I'm afraid, just a straightforward misunderstanding as to how the adverse selection is meant to operate. It doesn't require the non-cartelist dealers to have been able to detect and isolate their losses caused by the cartel at the time that they suffered them. Indeed, given that they didn't know about the existence of the cartel or which other dealers were in it, those non-participating dealers couldn't possibly have detected and isolated their losses. What is necessary is simply that they should have suffered losses, and they will have done so. And if they suffer those losses, then, as I've sought to explain, and as is explained in these expert reports, their reaction to that will be...
The essence of this sort of secret cartel
Yes.
is the victims of it are not aware that they are victims. Yes. Whatever the cartel, whether it's FX trading or
yes, indeed,
another sort of cartel.
Yes, indeed.
Not aware that they're being overcharged for whatever the product is.
Yes, that's absolutely right. And I mean, at the end of it's actually it's really the explanation can be put very straightforwardly. If you go to page 2704, if you see Roman 3, he says, in respect to the alleged false assumption that the non-colluding banks will necessarily widen their spreads, I disagree with the respondent's assertion that other market participants would have been likely to have responded by maintaining or narrowing their spreads in order to win more trades. The higher costs imposed on non-colluding banks through adverse selection suggest that they would need to charge wider effective spreads to compensate for these losses, and so maintain a sustainable business. If they chose instead to narrow spreads, that would imply that their business would run at a loss. It's really as simple as that. It's the losses that they suffer by trading with the participating traders mean that they have really only two choices. Either they start making overall net losses, or they have to increase their prices. And that's the essence of this strategy of raising the costs of your rival. So those are the sort of quick points I wanted to make about Mr. Kennelly's critique. On the judgment, my learned friend went to the paragraph 238 of the judgment. If I could ask you to please take that back up. It's on page 372. And at the top, it's the last sentence that my Lord Justice Snowden, I think, particularly focused on. If there is an arguable statistical case on causation, it should be pleaded first with disclosure following. And my learned friend suggested, oh, well, what that means is they ought to have had a model. Well, I've shown you that we certainly had a model. So if that is what was meant, it's rather strange. And I suggest that really what this is much more likely to be is a reference back to the analysis that you see on page 362 of the judgment. At page 200 paragraph 234, sub 3(1), where they seek to set out how a pleading might be framed, and they identify two ways that it could be framed. And the first, they say, is a statistical correlation between infringement and effect on market spreads could be averred. The essence of such a plea would be that whilst the transmission mechanism of an additional unlawful cost through the market would not be set out or averred, the statistical relation between the infringements found in the decisions and the effects on the markets was such as to amount to an arguable claim. That the explanation for this correlation was that the widened spreads were caused by the infringement. Connected to that, there is a suggestion also, you'll see on subparagraph 6 on page 371, that you see the last sentence of subparagraph 6 on page 371. The answer to this sort of problem is pre-action disclosure, and no application along these lines has even been suggested by the O'Higgins PCR. So what seems to be suggested is that we should have applied for pre-action disclosure of some data, then sought to establish a statistical correlation, and then pleaded it. And we respectfully submit that that is not the correct approach in these types of proceedings. And courts have made it very clear that disclosure comes after, provided, of course, you have a plausible claim.
I'm catching up just a wee bit.
Yes.
Just give me that reference to pre-action disclosure.
It's subparagraph 6 on page 371, last sentence.
Where did the cat deal with Namur?
In part in that paragraph 238 on page 372.
They deal with it earlier.
Yes, they do. They say that by their reference to Nomura in their letter, we should have inferred that strikeout was on the cards. Somebody will help me, I hope, with them. Page, I'm told, page 309.
309.
Yes, that's what you see the top of the page. Of course, the reference to Nomura makes clear the tribunal's direction of thought. But I think earlier on they also refer to Nomura on the importance of complete pleadings. So that is, I think, we haven't gone to Nomura, but of course that was a case of effectively an averment that couldn't be made, but we say an averment can be made.
And that's why I asked the question, because I wonder whether this last sentence of 7 is really tied in with the Nomura case.
It may be.
That's how I read it.
Yes.
Without
Yes.
having looked
Yes.
at Nomura.
Yes.
That last sentence is inconsistent, as I see it anyway, with what this court said in
Nomura.
Patrol and Goodman.
In Goodman, that's right, absolutely. And that's absolutely. And on that note, the in a sense to the process test, which has come in this very sort of roundabout way through another footnote in another judgment. And I just make 3 very short points on
That's
that.
the Microsoft case.
Yeah. The Microsoft, yes. Where it's suggested, and you'll see, my learned friend showed you that in the Gormson case, the president of the tribunal suggested that this was a case in which the Microsoft process test was not passed. And the short answer to that is, first of all, it was not argued by either the respondents or the tribunal that either of us had not passed the Microsoft process test. Secondly, if it had been argued and it was right, then that ought to have led not to certification on an opt-in basis. It should have led to no certification at
I was
all.
wondering, that's exactly the point I was about to make.
Yes. Yes,
If you didn't satisfy the Microsoft test, then you shouldn't have been certified.
exactly.
And yet the tribunal had no doubt that you should be certified.
Absolutely. So it's
Microsoft process is a pretty flexible test that doesn't dictate how now come yay or nay.
no, and that was my third point, which is that it's clearly satisfied. I mean, these are exquisitely detailed expert reports on both sides. They go into too much detail because they battle it out on finer points between them.
How do you get how could you get pre-action disclosure before you're certified?
I
mean, who gets?
Yeah.
I mean, in a sense, who's the applicant?
Yes,
What's their status
it's a very interesting question. I confess that
in collective
yes,
proceedings?
yes.
The normal pre-action disclosure, it's I am a victim. I would like to have, because I need to have
Yeah.
something to decide whether I'm going to bring proceedings or not.
Yes.
I need pre-action disclosure, but I'm a person in the ordinary course of
Yes.
sort of claims to have suffered loss. That's my very rudimentary understanding of pre-action disclosure. Whereas, how does it work with a collective proceeding, unless it so happens that the person who's seeking it is a member of the class? But before certification,
Yes.
I'm just...
I will, if I may, allow it to those next to me and behind me to look at the CAT rules to find the answer to that. But
we
it
also did
is a
touch on this in the
yeah.
in the Merrick's domicile issue case as to whether, and I can't remember the detail now, as to whether there was an issue there about when the proceedings were commenced, and I think it was eventually accepted. Certainly the in the judgment, I remember dealing with it on the basis that the proceedings were commenced when the claim form was issued, although the collective proceedings order wasn't made until much later. Of course, in that case, it wasn't made until 5 years later.
Absolutely, my lord, that's right. So the language of the statute is that collective proceedings cannot be continued without a CPO.
That's the point. That's
Yes, so
exactly
they start
the
on
point.
issue and
So
continue.
quick query whether at the time when the claim form was issued, the putative class representative who's issued it
yes.
would have sufficient jurisdiction to apply for
To apply.
pre-action
That
disclosure.
Sorry, at the risk of saying what's obvious, if you've already started the proceedings, it's not pre-action disclosure.
Well, that's also true.
That's true.
Yes.
But maybe they mean
so this is some
pre-CPO.
Certification disclosure.
Yeah.
Oh, so yet another set of applications to be made on this.
Not
Interesting road.
not to be encouraged from a case management perspective. Just
Sorry to interrupt, just to remind my learned friends that in this case, after they applied, they did seek disclosure before the certification hearing of contracts and the jurisdiction points. So there was.
No, we were ordered to do that by your side.
Well, the point is disclosure was addressed in advance of certification. It doesn't address the point my lord made, but disclosure can be
Well, that's why, I
addressed
mean, I wonder
before
whether the
certification.
tribunal, this is, I mean, in a sense, it may not be the most important point of all, but
No.
it does seem to be a rather curious
It's
sub-paragraph.
effectively saying you should plead evidence or without the evidence.
Because certainly in the other cases, the line that's taken, or the line that ought to be taken post Gutman, is disclosure doesn't come until after you're certified.
Absolutely.
Once you've got through the hoops of certification, and you've then got you've got collective proceedings order, that's the point at which the proceedings then follow the normal course of CAT proceedings.
I mean, it may be that somebody who, as a conceptual matter, a jurisdictional matter, somebody who is contemplating bringing proceedings because they are within the class, they are a victim themselves, they would claim, would have the basis to seek pre-action disclosure.
Independently, potentially, yes, as well. Yes.
But the vehicle for the collective proceedings of the type we're looking at here that couldn't do. Well, it's not immediately obvious.
They might be.
I would like to become a vehicle for collective proceedings. Please, can I have disclosure to see whether I can then formulate something to attract funding and support? It's
not a very attractive
It's a bit of a stretch,
proposition.
isn't it?
It doesn't sound like the sort of application that
No,
the courts would accede to.
Well, more to the point, I suspect that actually most defendants would find innumerable
I think the word
arguments to put in the way of such an application.
I think the word fishing expedition would be used more than once, wouldn't it?
Well, yeah, I'm
and-
sure that, well, and maybe with justification, but
Yeah.
it's just as a jurisdiction, just as a trying to understand how the procedure works, I'm struggling with what
We-
to say.
Yes, but I don't want to answer on the hoof. My instinct is that there probably is jurisdiction to do it theoretically, but it's not. It's not.
The relationship between certification and disclosure is important. This could have wider significance. I was just trying to wrap my brains for a competition case more generally where pre-action disclosure has been given. I throw that out as a half challenge. I was thinking, the issue I think came up, it was quite a long time ago, in the Hutchinson litigation in front of Mr. Justice Steele.
Yes, something.
Yes, that was, three were alleging a cartel
That's right.
against the other mobile operators. And
Responsible
even with
industry
benefit,
regulatory wide exchanges.
yes, and even with the benefit of then Mr. Sumption's advocacy, three's application was thrown out with indemnity costs.
Excellent.
Sorry, if I may, I appeared with Lord Sumption in that case, and the problem we had was
I won, you lost.
for sure. The point is that we did a follow-on action. We were alleging a standalone.
That's right, it was.
Standalone allegation of a cartel with no preceding regulatory finding in our favour in a pre-action disclosure case, which was very extensive disclosure against these operators. Very, very different in the case that we're contemplating now, which is a follow-on action. That was as far as I wanted to.
Yeah, okay.
But my learned junior, Mr. Rothschild, points out that CAT Rule 62, which does in principle applies, which allows for disclosure before proceedings start. And one of the conditions is that the applicant is also likely to be a party to the proceedings. Whether one could say that the CPO is likely to be a party to the proceedings, I suppose, would depend on the circumstance. One final point.
He's not a member of the class, but he is a party to the proceeding.
He is a party to the proceedings.
Once-
Well, yes,
once-
I suppose
once-
once issued.
Once the
Well-
CPO is made, the class representative is a party,
Yes, yes, but he's not a party
but he's
before
not a
that.
member
No.
of the class.
No, well, he may be. But
Well, he may or may
not,
not be.
Yes.
Okay, all right, anyway.
one final point. I'm going to leave practicability to my learned friend, Mr. Wakefield. That I just should correct one thing, that my learned friend referred to paragraph 24 of Mr. Higgins' first witness statement, where he said that the class, he said, was readily identifiable. He actually said the class is clearly identifiable. He was saying that for the purposes of Rule 74. In other words, it can be defined. It is possible to say of someone, are you in or are you out of the class? But Mr. Higgins goes on to explain that paragraph 27, which you'll find in it's in the supplemental bundle tab 18, why the class cannot actually easily be identified for the purposes of contacting them. So it is not easy to know how you're going to get hold of most of these class members.
Thank you very much. Yes.
Thank you. Just to complete the point on disclosure, lest your lordships are going to consider this, in the guide, which I know now is perhaps of less weight than it was hitherto, at least until it's revised, we have paragraph 6.28, which is Authorities 1, tab 4, page 18, and that relates to the first CMC. Now, when you put in your claim form and your supporting expert report, post acknowledgement of service, the first thing that happens is a CMC is listed. And it says in paragraph 6.28, or it conceives of an application being made then for specific and limited disclosure or the supply of information, and where that's necessary in order to determine whether the claims are suitable to be brought in collective proceedings. However, it has the warning that the tribunal does not encourage requests for disclosure. So there we are, that's the complete suite, I think, of references to it. So I'll start my submissions in reply, if I may, by dealing with a couple of points in relation to the regime as a whole. Merrick's and MasterCard, with which I know you are enormously familiar, and I apologise for taking you to it once again. I want to take you to it because this relates to a point made by Mr. Kennelly yesterday, and again today, namely that the respondents need protecting. And my Lord Justice Green said in the course of that exchange yesterday that perhaps there wasn't so much difference between the minority and majority judgments in Merrick's. I think there is such a difference. And I seek to make that good just by taking you to a handful of paragraphs. So if we go to the judgment of Lord Briggs, tab 33, Authorities Volume 3, paragraph 54. And I know you know this very well. Paragraph 54. There is nothing in the statutory scheme for collective proceedings which suggests, expressly or by implication, that this principle of justice, that claimants who've suffered more than nominal loss by reason of the defendant's breach should have their damages quantified by the court doing the best it can on the available evidence, is in any way watered down in collective proceedings, nor that the gatekeeping function, and those of course are the important words, of the CAT at the certification stage should be an occasion when a case that has not failed the strikeout or summary judgment tests should nonetheless not go to trial because of difficulties in the quantification of damages. On the contrary, as the Court of Appeal observed in that case, and similarly of course in our case, a refusal of certification, in this case on a knockout basis, of a case like the present is likely to make it certain that the rights of consumers, and I'll come back to the consumers point when I get to practicability, arising out of a proven infringement will never be vindicated because individual claims are likely to be a practical impossibility, and the evident purpose of the statutory regime was to facilitate rather than impede the vindication of rights. So plainly I say there's no indication at all that only meritorious claims should go forward if meritorious means anything other than non-demurrable. Similarly, in paragraph 59, Lord Briggs says, moving away from general background of the law and procedure for civil claims, the following points need emphasis about the statutory structure itself. First, the Act and the rules make it clear that subject to two exceptions, the certification process is not about and does not involve a merits test. And that's because the power of the CAT to strike out or grant summary judgment is dealt with separately from certification. The rules make separate provision for certification. And here we get to the key sentence. There's no requirement at the certification stage for the CAT to assess whether the collective claim form or the underlying claims.
Sorry, where are you reading from?
I'm halfway down paragraph 59, my lord.
59.
50, I'm sorry, I went too quickly.
Sorry, I was just noting something else.
So-
59.
We're about 7 sentences down.
Yeah, okay.
There is no requirement of a certification stage for the CAT to assess whether the collective claim form or the underlying claims would pass any other merits test or survive a strikeout or summary judgment application, save of course that the CAT may, as a matter of its discretion, hear such an application at the same time. And that's of course what happened in this case. And in paragraph
This
6...
is all said to be, in line 3, subject to the 2 exceptions, which is strikeout and 79.3.
Absolutely, my lord.
Yeah.
Absolutely, my lord, yes. But what I'm coming to is the concern to protect the position of the defendants, where the position of the defendants is referred to only in the minority judgment, and that's the point of departure, I say, between the two. So we have 54, 59, and Lord Briggs refers to the CAT's gatekeeper
Sorry, did
role.
I mishear you, or have I just been completely wrong? You said that that's what happened in this case.
So my reference there was to the end sentences of 54, where we know that in this case, if an opt-out order isn't made,
You weren't talking about 59.
I wasn't at that point.
No,
I
sorry,
wasn't.
right.
Sorry, my lord, I've gone far
Sorry.
too quickly. If we go back to paragraph 4, we see Lord Briggs articulate the CAT's gatekeeper role. So the CAT has an important screening or gatekeeping role over the pursuit of collective proceedings. First, collective proceedings may not be pursued beyond the issue and service of a claim form without the CAT's permission. That's the point we were just discussing. In the form of a CPO for which the representative must apply. The obtaining of a CPO is called certification. Secondly, collective proceedings may be terminated by the CAT at any stage by the revocation of that CPO. That's the point which my Lord Justice Green has made several times through the hearing, that it's a live issue. And then thirdly, the CAT may accede to an application by one or more defendants to strike out collective proceedings if they disclose no reasonable cause of action or are otherwise abusive, or to an application for defendant's summary judgment, just as in ordinary civil proceedings. So those are the 3 limbs of the gatekeeper role, and that correlates entirely to the application of the strikeout test for these purposes. Can I just say, whilst I'm here, that the Supreme Court had full sight of the pre-legislative materials, and we see that in particular in paragraph 20, which is on page 769. And your lordships will see in that paragraph, Lord Briggs extracts various parts from that consultation document and the response to the consultation document.
Yeah.
And all of those extracts emphasise the need for reform in the direction of opt-outs, because of course one already had opt-ins, fairness, we see at the top of page 770, but fairness to enable consumers and businesses who've suffered loss due to anti-competitive behaviour to obtain redress. And then by the second hole punch, introduce an opt-out collective actions regime for competition law to allow consumers and businesses to collectively bring a case to obtain redress for their losses. So those are the important parts of the pre-legislative materials insofar as they're featured in Lord Briggs's judgment. And we see absolutely nowhere a reference to opt-in, opt-out choice forming part of the CAT's gatekeeper function. We don't see that anywhere. We just have that reference in passing in paragraph 60 when he's saying there are these 2 references to where you can take merits into account or strength of the claim into account. And if anything, if one is to look for the position of the defendants in this majority judgment, one sees repeated reference to the need to disincentivise the unlawful conduct.
Just to be clear, what you've said is that it is part of the agenda of decisions that need to be made at the time that the CAT acts as gatekeeper, that it decides to certify on an opt-in or opt-out basis. I think what you're actually saying is that decision shouldn't be used as a sort of proxy or substitute for the question of are these proceedings with a reasonable prospect of success that are capable of going forward.
Absolutely, my lord. Given that you're against me on the jurisdictional argument, if it arises automatically, or if it can be considered as part of certification, I absolutely say that. It can't be used as a reintroduction of are these meritorious claims, and it certainly can't be used to do that in order to seek to protect the defendants, as if the protection of the defendants is a recognised part of the majority judgment, because it's not. We don't see that anywhere there.
So I don't think anyone, maybe Mr. Kennelly, not something that's being disagreed with. The only question is, underlying this, one of the reasons why you have certification is to protect defendants. So the very system, the Bay's government response to the consultation was, how do you protect defendants? It is because you don't just allow claimants to start proceedings choosing opt-in. You impose a certification stage. And that in itself is the protection which is required to be given to defendants. So we've got here strength. I mean, I think there's some force in saying that if you meet the strikeout, it's going to be rare that the court will find anything more to do. More likely they'll say, well, we've got a super strong case which might have an impact. It's unlikely they're ever going to be in a position to say, we think this is proceedable but weak, and therefore we're going to use that as in the way. I mean, it may not be inconceivable that it would happen, but hard to imagine a case where weakness of an arguable case is relevant as opposed to super strength of an arguable case.
Well, I think we may well be ad idem then, and so on strength of the claims, that's exactly my position, that one can't introduce some kind of need for a better than
No, I mean, it's just the intrinsic
claim.
merits. They have merit or they don't.
Absolutely, and so
It's not weighted because of some policy consideration.
it's not weighted.
That
Absolutely,
goes into the structure, not the merits evaluation at this stage.
it goes into the structure, into the need for a CPO. I'm shortly to go to Lloyd and Google and show that one doesn't need to have a certification stage as a matter of general policy, but one does in this regime, so that's fine. And there's no need for anything additional. When I come to practicability, shortly, of course, I'll need to grapple with Mr. Kennelly's arguments that it's the protection of the defendants, it's the unfairness to the defendants that means that his construction of practicability should prevail. So these submissions are relevant to that limb as well, my lord. I'll just deal with two paragraphs of the minority judgment while I'm here, because I did go to one of these paragraphs before in the course of my submissions. So the minority judgment starts on page 790. And over the page 791, we have paragraphs 84 and 85, which are in line with Lord Briggs's judgment. And then we have paragraph 86. And I say this is where the handbrake is applied and the minority go off in a different direction. Experience in other jurisdictions, however, has also shown that a class action regime presents risks. In particular, there is a risk that speculative actions may be brought claiming large amounts of damages, even where there is no realistic prospect of recovering such damages, but where the size of the claims and the heavy costs of defending the action may be used as a threat to induce defendants to settle. In introducing the new regime in the UK, the government was alert to this risk. Immediately after the passage quoted above, its response to the consultation on options for reform continued, recognising the concerns raised that this could lead to frivolous or unmeritorious litigation. The government is introducing a set of strong safeguards. And then we have these strong safeguards were said to include strict judicial certification of cases so that only meritorious cases are taken forward. And I say it's principally at the end of that paragraph, first of all in identifying the risk, but then at the end, in the implicit recognition of the need for strictness and the test of meritoriousness, if that means something different than non-strikable, that we see the minority go off, depart from the majority. If I could just take you to the very end of the judgment, my lords. We see in paragraph 174, in the conclusion of Lords Leggett and Sales, the beginning of 174, they acknowledge that some of the claims brought in Merrick's, even on their view, were non-strikable and had sufficient data and support. And then halfway through that paragraph, But it was a separate question whether it was suitable for them to proceed as a collective proceeding with the substantive legal advantages that this would give to the claimants, where the applicant could not show that data existed or were likely to exist to make the action viable across the whole width of the claim. So that obviously has some resonance with the Class A, Class B conversation that's been taking place today. In Merrick's, there was a variety of quality of data and evidence for the different sectors. And certainly as the hearing went, there was a focus on what should happen to those sectors in relation to which there wasn't much data. Lord Briggs says the whole thing should be certified. Let's see how we get on. And Lord Sale and Leggett say, well, if any of it is weak, the whole thing should go. And one of the reasons in support is the categorisation of opt-out proceedings as unusually beneficial to the claimants. And so I do say...
175 contemplate that you can have a split CPO.
They do. They do, yeah. In the course of the hearing, they discussed that and they contemplated whether that was possible. I'll come back in my practicability submissions to whether that is possible and how on earth that would work, at least in this case. It was said yesterday by Mr. Kennelly, turning away from Merrick's, I think by reference to the 2008 CJC report, I paraphrase here, but essentially that there's no jurisdiction in the world where there are opt-out proceedings without some kind of strict control. Now, in Lloyd and Google, which we have in the bundle at tab 39, obviously we were arguing for the use of 19.6, CPR 19.6, for a class of many millions of people. I think it probably does make sense just to open it up. So that's Authorities, Volume 4, tab 39. And here, of course, it was Lord Leggett who gave the judgment of the court. So if we start on page 1050, I note in passing, just in paragraph 3, that again, I'm afraid that the court was beleaguered with all of the pre-legislative material on this issue, and they note the CJC report, and they note that the report was rejected, obviously, by the government of the day. The recommendation of the report was that there should be a general regime, and instead there's a sectoral regime, with so far the only sector being this one. In the course of considering whether it was appropriate and proper to use 19.6 for a very sizable opt-out consumer claim, they surveyed the various regimes in the UK. We have that in paragraph 24 onwards. GLOs, first of all, and it's in that section that one finds the passages which are extracted and relied on in your lordship's judgment in Le Paterel.
Yeah.
Then we have collective proceedings, and then we move on to 19.6. From para 59 onwards, their lordships consider the Commonwealth position. And I rely on this, of course, because of Mr. Kennelly's reference by way of the CJC to any other jurisdiction.
How does his argument feed into any point of construction which is relevant? Just trying to get my head around.
I think he was saying one should construe the regime here strictly because you always need a strict regime. And I'm about to take you to the paragraph in Lord Leggett's judgment where he says you don't need a strict regime.
Okay.
So Australia, Canada, and so on. Paragraph 67 on page 1068. And we see 67, Lord Leggett sets out the compelling advantages of allowing an opt-out claim, a mass claim, in which one doesn't need to become a party. That's the only practical way to come at justice. That's the language of the 19th century cases. Then in 68, he says, I agree with the highest courts of Australia, Canada and New Zealand that whilst a detailed legislative framework would be preferable, its absence outside competition law is no reason to decline to apply or to interpret restrictively the representative rule which has long existed and had that legislative basis for a long time. So that's simply to rebut Mr. Kennelly's contention that opt-out proceedings or the mass vindication of rights without a mandate from the class is some kind of aberration which needs particularly strict control.
We do have to have a mandate from the CAT, and it either gives it
From
or
the
it
CAT
doesn't.
we do in this regime,
And that's
absolutely.
what's meant by strict.
That's-
It's structural in the sense you've got that regime.
We have that
The
regime.
question is whether beyond that you then add some strictness when you're looking at any of the individual criteria.
Absolutely, absolutely, my lord. We have the regime we have, and it's whether we add things onto it and how we construe the things we have in the regime. That's exactly it.
And the three policy objectives that the Supreme Court identified and we identified were access to justice,
Disincentivisation,
disincentivisation and
economy.
judicial efficiency.
Yeah, absolutely, absolutely, my lord.
And they may play out in different ways in different cases.
But no need for, in and of itself, a direction of a strict gatekeeper function or that it's otherwise unfair to the defendants to have claims go ahead. That's
In
my
one sense, the CAT is always going to at least be conscious of the fact that you are letting loose a giant claim and you want to do so on a proper basis. So you look at all the criteria, you make sure the representatives are up to the game,
Yes.
you make sure the case is meritorious, you make sure you can properly case manage it,
Mhm.
and that is the basis upon which the proceedings then become fair to all parties.
Absolutely, my lord. And no shifting from that position. If I turn now
And
to...
I suspect any judge, when looking at a case that you think is speculative, you're going to be conscious of the fact that you are letting loose a monster. I mean, you can't, and that's not built into the structure of the analysis. It's just
not. It's absolutely not. And it's repugnant to the general approach, as per the Brazilian dam case, which my Lord the Chancellor referred to this morning, a general apprehension of the behemoth, of the magnitude of the thing before one. It is not a basis to strike out a claim or to give summary judgment against it or to not allow it go forward. And we have clearly in Lord Briggs's judgment the direction that we do not have additional barriers in the way of collective proceedings that we would not have otherwise.
once Parliament's decided that the regime goes ahead, it recognises the consequences of that.
Yes,
It lives with
it
That's
does.
what Parliament has intended.
That's exactly so, my lord. Yes.
I mean, the size of the case isn't a reason to not let it go ahead, simply because otherwise it would be the worse your conduct and the more people you injure, the more likely you are to get away with it.
Yeah.
But it does mean that the court and the parties, it's not just the court and the tribunal, it's the parties as well, have a responsibility to conduct the litigation more efficiently the bigger it is.
Yes, my lord. And we see that in Merrick's, and we see that...
All of which were points which were made by the Court of Appeal in the Brazilian dam
They were.
case.
They were absolutely, my lord.
Did you write the judgment? Sorry? Did you write the judgment?
No, I wasn't. No, I gave a lecture
We
If I...
only ever talk about our own judgment. No, I wasn't in the case.
Sterling lads, Mr. Joel addressed you on Hollington and Hewton. I won't address you on that point, but yesterday my Lord Justice Green asked, and this is at page 151 of the transcript, what about this, one last go, to say we have 3 decisions, 2 of which are settlement decisions, and then we have Sterling lads. We assume that the Commission adopted the same theoretical approach in all 3 cases. Can we therefore assume that this 400-odd paragraph decision is reflective of the approach they would have taken had it not been a settlement decision, had it been a full decision in the present case? Now, I say that's a very good point, and in fact it's an even better point than my Lord may have appreciated. I don't know if you did appreciate this already, but we don't in fact have 3 decisions, we have 4 decisions, because there are 2 Sterling Lads decisions. There's a Sterling Lads settlement decision as well. And the settlement was with Inter Alia, UBS, Barclays and RBS, so 3 of the banks who Mr. Kennelly represents today. And we have that settlement decision in Authorities Bundle 6 behind tab 61. And if you open that up, my bylaws, and then also open up one of our decisions, which will be at the beginning of Key Docs, Volume 1.
Yeah.
You're going to say they're very similar.
They're basically the same. Yeah, they are. And so I
So Essex, nabs and banana splits,
yeah,
basically the same.
they're essentially exactly the same. There's the odd, I won't do I was going to do a tedious page turning exercise saying same paragraph. But you have the point, it's essentially verbatim. Occasionally one has a different paragraph inserted, occasionally there's an and or something. But the nexus between the long Sterling lads and our settlement decisions is much tighter, I think, than would otherwise be appreciated, because we know it is squarely elucidatory of what lay behind this sort of settlement decision. My second point in relation to Sterling lads is this, and essentially I endorse Mr. Joel's submissions that plainly I say, is relevant to strength of the claims. It gives a bigger tick, and I would rely in that regard, not least on the way your lordships treated the Ofcom decision in Le Paterel. So in those paragraphs of Le Paterel, I think it's around paragraph 106, your lordships say, well, the thing that gives this an even bigger tick is that although the Ofcom decision could not be relied on at trial as evidence of the truth of the statements within it, etc., it shows the plausibility of the harm that's alleged in this case. And then finally, in relation...
I think, if I remember, I think that was a settlement. I think BT agreed to the account credit without there being a formal decision.
That may be right, I don't know.
Well, just remind us where it is. It's tab.
Le Paterel,
Yeah,
it's, I think, 44,
which is in
volume 4, tab 44.
Yeah.
And it is paragraph 106. So that's page 1257.
1257.
1257. 106 is at the top of the page, and the most relevant part is between B and C.
So I think it was non-binding because I think it was a settlement.
Exactly.
But yes. But we were careful to put in that sentence, I remember.
Quite.
Agree that it needed to go in as a caveat or qualification.
Yes, I can see that. But when one's testing, well, it's not probableness of my claims, because they don't need to probably be right, they need to be non-strikable. If the question really is, if this is genuinely a live question, could there be summary judgment entered against these claims, then plainly this would be Sterling lads as a limb in the wall of the reasons why I say no. But I say, frankly, we're very far above that. You have my submissions.
Well, Hollington and Hewthorne is really about the sort of case where, putting it colloquially, the English judge is invited, or an English and Welsh judge is invited to effectively decide the case on the basis of a previous decision in that case by another judge in another jurisdiction.
Yeah.
And as it were, abrogate responsibility to another judge. I mean, that may not have been how it started off, but if you read those two paragraphs from Lord Justice Christopher Clark, and that's all part of the trial process. It's got nothing to do with what happens at an interlocutory stage.
It is, my lord. Thirdly, in terms of what might happen at trial, it was a commitments decision. In terms of what might happen at trial, there is a letter in the bundle at tab 84, which I think may not have made its way into your bundle.
84.
People are rushing around trying to find the hard copies, but I'll summarise it. In essence, we wrote to the CAT in December 2021, saying there is a decision, Sterling lads, at that stage only the press release. We summarised the ways in which we thought it would be relevant, and we said in due course we would seek to apply for permission to amend to bring follow-on proceedings in relation to Sterling lads. So it wouldn't be that in these current collective proceedings, we would be relying on it by way of similar fact evidence, or however one might try and do it, absent Hewthorne and Hollington. Oh, I have the letter.
That's reflected in footnote 2 of the judgment.
Is it, my lord? Gosh, you're more familiar with it than I am. Can I just pass this up? And you'll see, because it's a continuing competence case under the Brexit regime, we're able to do that. We're able to bring follow-on proceedings in relation to that decision. So if the question is, what will it look like at trial, whenever we finally get to trial, by the time of trial we may well have the full fact version of Sterling Lads as a decision in relation to which we are following on, at least as far as Credit Suisse is concerned, and then we'll have an argument about the proper construction of the settlement decisions.
Yes.
I turn now to strength of the claim, and in large measure, obviously, I rely on what Mr. Joel has said.
Somebody has helpfully, so where does this go?
It's tab 84, so I think it should slot into your key documents bundle in that place. Yeah, the intention is that the tabs hold good throughout both runs of documents, which is why your tab numbering in that bundle will be patchy. We should have handed it up with a tab attached, I'm sorry about that.
Don't worry. So if we put it in our bundle after the letter from the cat on the 7th of October.
Yes, my lord.
Yep. Yes,
So-
sorry, you were going to say something about the strength.
I was turning to strength of the claims, and of course the division between my learned friend and me is that he takes the lead on it and I just sweep up. So I won't say much in that regard. I will, however, say this, that your lordships now are astute to the difference between my Class A and my Class B. It was said by Mr. Joel in the course of his submissions that in fact there's such an interaction between the two classes that the two collapse into one another. I'm not going to preempt carriage submissions and so on, but of course from our perspective, yes, of course there's a degree of feedback, but they both could survive separately. So one does not depend upon the other for its success. For Class B, of course, we have the ASR, theory of harm, the adverse selection risk, but we also have the lessening of competitive constraints. So if your lordships in due course go back to my August pleadings, the ones that followed that letter after the hearing, in which we set out in granular detail our theories of harm and how these various causal mechanisms took effect. We have harm type 1 to Class B, which is classic umbrella, Coney style, just raising of prices on the dealer to customer market. And then we have the ASR, adverse selection risk, on the interdealer market. And we set out in considerable detail in that document how those mechanisms would have worked in this market. And we addressed degree of switching, we addressed degree of transparency, we addressed market power, we addressed how one person in the trading room would affect everyone else in the trading room. And in that regard, we have the evidence as well of Mr. Knight. We have the cross-references to that in my August pleadings. But Mr. Knight explains how someone with the positions that those traders had would have issued guidance to the whole desk, would have had power to intervene into trades, to direct trades, would have had the ability to take to themselves the most sizable and important trades, and he sets out the various ways it would have worked.
That's essentially underpinning your Class A claim.
That's my Class A claim, absolutely. This is my Class A claim. But we explain how Class A sits with Class B and the different mechanisms, and we rely on the abundance of evidence that we submitted below and which I've taken you through only skimming along the top of the detail. And I don't want it to be taken against me, I hope very much it won't be, that I haven't cracked open every page of Rhyme, I haven't cracked open every page of Ramirez. And I do so, and I'm sorry this is discourteous to Mr. Kennelly, but although he's very charming when he leans forward and says, well, it simply can't be the case that prices would have gone up. I have all of my experts and he has nothing apart from his assertion. He's not an expert. And it's really impossible for him to get home on that, I say. So there we are. I'm not going to address the theories of harm for Class A and Class B.
No marks for charm.
Sorry, very charming, but my learned friend Mr. Joel has spoken about the mischaracterisation, inadvertent doubtless, of the need for us to, or for the trader to isolate the loss in the ASR risk, and about the aggregate nature of the perception that one is losing out in the interdealer market. Accidentally, I think, I'm sure, Mr. Kennelly appeared to attribute to Professor Rhyme the statement, they still need to isolate the loss based on a perception that they are facing a better informed counterparty. So use that word isolation. We don't endorse the word isolation. That's at page 121 of yesterday's transcript. And that isn't to be found in Professor Rhyme's evidence, and it would be wrong. I turn now, if I may, to data and variables, and I'm very much not going to get into anything to do with carrying.
Do you want to do that after we've had a break? So we have a break for 5 minutes.
Of course. That won't take me long. And then on practicability, I've only ended up with that, so it depends what. I've given up trying to go quickly. Maybe because I suppose the languorous questions, and then I choose the next track. It's just the same. I don't think I got the answer very interesting.
Judgment is so for you.
I know, it's just like something to suggest that. They can't sit till 10, but they can sit till 4:30 today, can't they? So if I'm hopefully done in the next kind of 15 minutes, then about half an hour. That's true, that's where the cookie crumbles.
Patriarchy is on the
Isn't it? No, sorry.
Skeletons were in yesterday, so that's what we don't lose much face to face. We used to have Tuesday.
What do we recognise as a common?
They said just holiday.
Maybe we'll wait for us to see what happens.
Yeah, some things are
You stay charming, we like it.
I'll try this.
But he was it. That's right.
Wilson, hello. More for the collegiate bar. Take it too far. You're the back stiffly. I did think Diana was shaking.
Yeah, she would.
She just hit you.
She would have just sat there like kind of staring.
Hit her.
She's steely when she's
Yeah.
pregnant.
But life's too short.
No, I get it.
Oh, no, not me, no. It sounds like it's you know what? I have free work for you to see if I can always see. So I don't still have to deal with this in 5 years' time.
All right.
Mr. Campbell,
I have to check my hair in the mirror.
you seem to be getting even hotter.
Cheers, Ethan.
We have tried to do something about it, but whether it'll succeed. There's always a problem as the day goes on. For some reason, the courtroom gets hotter and hotter. Sorry about that.
Turning to data and variables for the causation analysis for Class B, and as I say, I'm going to seek not to trespass into points that will be made, I think, tomorrow now in the carriage context. Mr. Joel referred to how useful defendant data for the non-cartel period would be for the assessment of loss for Class B. And I took you yesterday to my claim form in which we said expressly that we would use that defendant data for the non-cartel period. So you have the claim form in key documents, tab and volume 1, tab 4. And in fact, it may make sense just to look at the class definition even, that in paragraph 72, which is on page 125,
Yeah.
you'll see that the Class B class definition includes those who entered into trades, if you turn over the page, A Roman 1, with an RFI, so that's non-respondent dealers, and or a defendant during that defendant's relevant Class B period. So we had filed with the claim form a distinction between Class A periods and Class B periods for defendants. In paragraph 75, which starts at the bottom of that page, I took you through this yesterday. We set out how we're going to show harm. And if we go forward 2 pages to page 128, at the start of this page, at the top, we have Roman 1, and then we have a normal 2. And I took your lordship through this list of different data sources. But of course, you'll see Roman 1, the proposed defendant's transaction data to measure harm during their relevant Class B periods. So that's exactly the same as my learned friend, Mr. Joel. If I turn now to the report of Mr. Ramirez, which is in this same volume, Ramirez 1, at page 605 and paragraph 130 onwards, title 6.2.1, which is at the bottom of page 605, measuring harm from less competitive market conditions and increased adverse selection costs for proposed defendant transactions during the relevant Class B periods. So that's using transactions with the defendants during their non-cartel periods, and he sets out how he would go about it in that part of his report.
Yeah.
Turning to variables, briefly, if we go earlier in this same report to page 594, Mr. Ramirez sets out explanatory variables. Now, I wanted to take your lordships to this. Yesterday, we didn't have this in your bundle, so I'm just showing you where it is for today's purposes. And we have over the various paragraphs which follow, and Mr. Ramirez having identified how critically important it is to get these variables right in this sort of claim because of the importance of the regression analysis, he seeks to identify them as best he presently can from the literature. And he says, of course, that disclosure of the chat rooms, defendant data and so on will help him go further in the identification of those variables. Now, one of the variables which he identifies in paragraph 116 relates to customer-specific factors. Mr. Kennelly yesterday sought to try to make some headway, I think, by taking the court to cross-examination, first instance, from Mr. Hoskins, Queen's Counsel as he then was, to Mr. Ramirez, in which he said, well, because much of the data, not the defendant data, but the data from interdealer platforms and some multi-bank platforms, because that's anonymous, you won't be able to control for customer-specific information. But of course, the short answer for that is the trades which took place on those platforms were themselves anonymous. So that variable isn't a relevant variable for those data sources. You don't need to control for customer-specific factors when one looks at Reuters data, because nobody knows who the customers are. Similarly for SIBO. So in fact, that was...
Sorry, I run that one past me again.
So when one trades on the Reuters platform or on some of the multi-bank platforms, not all of them, but some of them, including SIBO, the trades are themselves anonymous at the time of striking the deal, at the time of the trade. One doesn't know the identity of the customer. So a relevant variable for in the dealer's mind when pricing, a relevant factor to be controlled for is not customer identity. The trades themselves are anonymous, so when one is using that data...
Wait a minute, you won't know who you're trading with, but you'll know your own...
You'll know your own information.
Variables, your own...
That's right.
Factors, your own... So you're, wait a minute, you're talking about customer...
Customer,
specific
exactly.
factors.
The variable
and
is
so
customer
this is only
specific.
where you're looking at... Not into dealer, you're looking at just... Yeah, okay.
Yeah.
Just the customer
Yeah.
piece.
Yeah, absolutely. So we don't need to, so it was a wrong line of questioning, essentially.
Yeah.
It didn't get anywhere. It seemed like it did, but it actually didn't. If I hand up as well a short extract of the transcript below in relation to CLS data, we will have this in our bundles. It's at page 4164 for us. This didn't make its way into your key documents, I'm
Is the
afraid.
gist of this that you can account to an appropriate degree for variables?
Yes, you can.
Is that the point?
That's the point.
In some way, shape or form?
In some way, shape or form, you can account for them. Yes.
And whether it works
I'm
is
pleased to
matter
hear
of
it.
trial.
If that's right, then I can...
Either works or not, but that's for trial.
That's for trial. That's for trial.
Yeah.
In the light of that indication, rather than take you through the discussion about whether CLS trades were or were not anonymous, I'll just direct you, if I may, to the top of page 4167. In fact, if we have to look at the previous page, the bottom line of 4166, and we see Professor Rhyme. It was a hot tub, so they were all there together. And he intervenes in Mr. Joel's cross-examination of Mr. Ramirez, and says data from Reuters and EBS are supposed to be used to measure adverse selection, and for that purpose, these are the perfect data. So earlier today, Mr. Joel said, oh, well, the reason Mr. Ramirez thinks they're useful is, well, he doesn't understand FX microstructure. But we see that Professor Rhyme, who is the guy, so far as that is concerned, says, brilliant, Reuters and EBS, that's exactly what I would want to look at. And that's the data we'll be using.
Right.
So there we are, variables, data, and so whether one's applying process, and obviously the tribunal held that implicitly at least that we satisfy process because they were going to certify us, or strikeout or summary judgment or whatever it is we have to satisfy, strength of the claim, we are wildly over it it. And I might also say this, whilst of course I fully acknowledge the importance of proper case management, in particular in this sort of case, I would say that we are very far away from McLaren, from the second half of McLaren, in which this court said, well, the CAT, as part of its gatekeeper function, now needs to do some pretty strict things to work out what's going on. Because in my submission, and I'm aware this isn't strictly speaking before your lordships today, these cases are in very good nick, if I can put it that way. We have our developed theories of harm, we have our experts, we have our methodology, we have our examples of how regression is going to work, we have our data sources, we have our ways of testing for variables. We know the sorts of things we're looking for on disclosure. Obviously the chat rooms, but if there's anything internal about pricing decisions, about reactions to the market, we know what we're doing. It could just go to a normal CMC. But anyway, those are my submissions on that.
Yeah.
I'm going to turn now to practicability. Point one, and this of course was a point made by my Lord Justice Green. Mr. Kennelly's approach to practicability essentially omitted entirely statutory objective of deterrence, the secondary statutory objective as set out by the Supreme Court, and similarly omitted the secondary, or tertiary, I suppose, however one puts it, objective of procedural efficiency and economy. So he wrongly elevated one of those considerations, access to justice, above everything else. My second submission is this. Such was the strength and overarching nature of his submissions that in effect he was contending for a carve-out of larger businesses from the opt-out regime. It would be very difficult to distinguish between the submissions which he made to your lordships today in relation to the reasons why those bigger businesses should not be there and arguments that should succeed in any other case. Effectively...
Further than that, it's any company that is sufficiently sophisticated to conduct litigation.
Absolutely.
So including a company that has a claim for £15,000.
Absolutely, my lord. That really was the test, wasn't it, of his submission when he looked at that low value column and said, no, of course, it's up to them. They choose whether to sue for 15,000 or not. And if they don't, then it's up to them. They're out of the regime. The regime created by Parliament, which has no mention of that on its face, is not for them. They're excluded from it. And that would apply in my submission. One can't say in every single case, but I don't see why it wouldn't apply in every single case. It effectively restricts the entire regime to consumers and very small micro enterprises, I suppose. And I say that's a complete distortion of the regime. My third point is that alongside that set of submissions, he essentially endorsed some kind of inquiry into motive. It was a bit difficult to understand exactly which motives for not litigating would be classed as benign and so still would allow one to access the regime, and which ones are reprehensible or just indicative of making one's own decisions so you can't benefit from the regime. It's pretty difficult to tell. But we know from the multiple considerations of this regime by all the higher courts that one is in general concerned by the low take-up rates of opt-in proceedings. The background to having opt-out proceedings is that claimants do not opt in. And they don't opt in for a multiplicity of reasons. And those reasons may include indolence. They may include a lack of general commitment and organisation in one's life and in one's affairs. They may include a cost-benefits assessment, where for that particular business or person, the risks just aren't worth it, the game's not worth the candle. All of those reasons come together, and they are all in my submission benign for the purpose of opt-out proceedings. They are not the sort of reason that should exclude a claimant from the benefit of opt-outs. It's precisely for that reason that we have the opt-out regime. So that's my third point. My fourth point is even if one were to launch into some kind of moral inquiry into benign or malign motive, you have the evidence of Mr. Mayton of Housefield, where he went to those high claiming, high value, high sophistication entities spoke to them about why they didn't want to opt in or to participate in a GLO style structure. And those 4 reasons he set out in paragraph 19, essentially a combination of can't get the approval, don't have the documents, it's not really worth that amount of money, can't get the sign off, don't want to break cover, all of those different reasons. And I say those are all benign reasons in any event. So the evidence in this case supports me. And of course, we have absolutely no evidence in relation to the vast number of the class. He approached 300, the top 300. We know nothing about the rest. And the tribunal purported to make a finding in relation to the class of 42,000, so not the penumbral extra 60, the 42,000 in relation to whom Mr. Ramirez gave his evidence. The tribunal purported to make a finding that they were not litigating because they did not want to. That was absolutely off the table, I'm afraid. That was not open to them as a finding on the facts. The only evidence they had in relation to the top ones also was compatible with the regime. You have my submission on that, but no evidence at all in relation to the bottom end. My 5th submission is if I'm wrong on all of that, and if one were to take the view, oh well, the top 300, they have to opt in, but the rest have to opt out. I say we come crashing up against those problems of principle and of practicability itself, which your lordships put to Mr. Kennelly this morning. Now, I don't know if your lordships are aware of it, but this is an application that was actually made in McLaren at first instance. So we have that in Authorities 6, tab 42.
Sorry, what was an application made in?
To have the top value people be opt-in.
I very good remember.
Yeah.
Yeah, so
Tab 42, which is in Authorities Volume 4. Sorry, I gave you the wrong reference. Tab 42. Page 1198. The title involved in is G, opt-in or opt-out, large business purchases.
Oh, yeah.
And I'm not going to read the entirety of the 1198, my lord. Paragraph 151. So first of all, under the heading the Tribunal's powers, the Tribunal, chaired by Mrs. Justice Falk, expresses serious reservations about whether they even have the power to make the order sought. So we see that in particular paragraphs 156, in which the submissions of Ms. Ford are summarised. She submitted it was not contemplated by the legislation or CAT rules, which only envisage a choice between opt-in or opt-out as a whole rather than part of them. The Tribunal says we see real force in Ms. Ford's submission. And then they talk therefore about the potential for abuse by, I suppose, wrongly having people in opt-out. And instead, that should all be sorted out at the certification stage under that regime. Then 2, the basis for seeking certification on an opt-in basis. We see that those higher value claims. 3, which is at the bottom of page 1201, the discussion. And the Tribunal says, irrespective of whether we would have had jurisdiction to accede to the proposal, we've concluded it should be rejected for the following reasons. 162, it's totally bootstrapped, it's arbitrary. One just takes an entire class, randomly draws a line through it, and hives off the top end of it. Secondly, this is my Lord Justice Green's point, seriously questions the efficiency of conducting claims, which are combined by a single PCR in that way. 164, this was the point I think made by my Lord the Chancellor. Well, it's going to be opt-out for the vast majority of the class. That's the same in our case as well, obviously, numerically speaking, overwhelmingly opt-out. Then 165, we don't see how it could be subdivided. How can you do that clearly? Any choice is arbitrary. This is the SME point. It won't necessarily be apparent to the class members which category they fall into. And so the Tribunal says we just reject it. We say that's not available. It doesn't work at all. And I say that's entirely right, and it's right in our case as well. It almost goes without saying that any such split approach will bring with it terrible difficulties in terms of funding and structure, and who pays for what when, and whether the opt-out would be kind of paused pending buy-in of the higher value people. And of course, in our case, in any event, the facts are that the top end people wouldn't opt in anyway.
This is
So-
her analysis on the facts. I mean, it's a different question whether jurisdictionally the CAT could do so. I mean, they express some doubt about it.
They do, my
Is there
lord.
anything which prevents it? We were trying to imagine for ourselves what sorts of circumstances might feasibly give rise to an in and out in one go.
I can't imagine any. I know that your lordship has expressed to me several times in the course of this hearing their desire never say never, and perhaps never say never, I don't know, but I can't imagine
We never
the
say
case.
never if there's no jurisdiction.
Well, is that,
So the question
yeah.
is whether it's something which the CAT might in extremis consider if they're allowed to do so.
well, there's no indication in the statute or the rules that it can do so. It's expressed as a binary choice. The statute says
You could
specify in the order.
You could manipulate this position, put limitation questions aside for a second. You could simply say, well, I'm not going to certify one set of proceedings, but if you just come back with two separate
orders, perhaps.
sets of proceedings, I would certify it twice and run the two in parallel. The question is,
Why would you do
why
it?
on earth would you do it?
Why would you do it?
Jurisdictionally, I mean, you subject to questions of limitation,
Well,
etc.,
because, I
etc.
mean, the
You
whole-
could do it.
One of the points of the collective proceedings regime is to have proper case management. So the class is represented by one
Absolutely.
class representative and
Yeah.
by one set of solicitors and counsel.
Yeah,
No, I mean,
absolutely. And I do
The
think
big problem is you would give rise to all sorts of issues. I mean, if you had the same person acting as class representative in both sets of proceedings, you might have a problem with one set of proceedings settling and the other not.
absolutely.
If you had two different class representatives, you inevitably would give rise to greater cost, expense, and fall foul of the third policy issue behind
Absolutely. And there must
the
be a
whole
risk
collective regime.
there must be a risk as well, I think, that the opt-in people gain too much say over how the proceedings are conducted, because of course this isn't quite like a GLO, but nevertheless there is a conventional retainer. You know, they could give instructions, and it's not really fair, is it, to have those 30, 50, 100 people at the top end able to influence what happens in court in the tribunal in a very direct way, when the vast tail of people don't have the same engagement or facility to engage with what's going on.
The difficulty with saying you could never do it is that you could have a claim in which you've got one or two very, very large potential claimants and a lot of small. And the one or two large decide, well, we don't want to be involved in that. We can see why the smaller companies or individuals wish to bring a claim. We will bring our own standalone claim in the CAT.
Yeah.
And we'll ask the CAT simply to run them two together. We want to give disclosure. We want to run our own witnesses, our own evidence. We'll cooperate and we'll be case managed. Why? I mean, I suppose the CAT wouldn't certify them as opt-in. They'd just be a standalone.
They'd just be a
claim plus
standalone,
opt-out.
exactly as Mr. Kennelly referred to earlier.
Yeah.
And in that way, this is the point I sought to make on the first day, in a way the regime is self-policing, because if people want to come forward and participate, if they're in an opt-in, they'll opt in. They can bring freestanding, standalone proceedings or freestanding follow-on claims or however it is, or they could just not opt out of the opt-out class. They'll be there one way or the other.
Yeah, or your couple of institutions that my lord was postulating could simply opt out and do exactly what, if
Absolutely.
there was just one set of proceedings, they just opt out.
Yeah.
Well, that's effectively what's, it's in reverse order, but those who participated in Allianz would obviously be excluded from our claim. That all of their loss has already been litigated, that's gone. It was discussed in an exchange with the bench whether one way of dividing between big and small for the purpose of opt-in and opt-out would be claim size, and Mr. Kennelly said no, that wouldn't work. He obviously was right to make that point, but the reason why that is, I think, an inevitable concession is, of course, recovery is dictated by distribution, and distribution is normally to be resolved at the very end of collective proceedings, and we know that from Merrick's. Not always, but normally you don't bring that forward, because we know that in many cases, not all, and not ours is one example, but in many cases there may be flat rate recovery at the end. So pursuant to the aggregate damages power, section 47C, even though everyone has suffered a different amount of loss, via the proceedings, they will recover the same amount, and that's why claim value is inapposite for drawing a line. And finally, I think I'm always...
Does that undermine the dog and the tail?
It doesn't undermine the dog and the tail. No, because for that, one is thinking about opting in, I think. And so for that, one would have to form a view by reference to one's own data.
Yeah,
It's
think,
difficult
hang
to...
on, at the risk of mixing animal metaphors, you may be trying to kick a gift horse in the mouth here.
Okay, well, I'll stop kicking.
One of the concerns I had in relation to subparagraph 10 at page 437 at the last bit, which is where the dog and the tail appear, is that the cat seems to have talked about claim size as being the determinant of the dog and the tail. And I think you're saying claim size is impractical.
So claim size is certainly very difficult in opt-out proceedings seeking an aggregate damages award. It's very difficult to form a view on ultimate recovery at the early stage. If one is asking the question for those purposes, how likely is it that that person will opt in? And in opt-in proceedings, it may well be ultimately that damages are divided up in a more conventional way, because that's why people are opting in the first place, I don't know. And then it would be possible for those smaller micro enterprises, for example, to form a view of their likely loss. But I see that I see the tension between those two, but it's big. The reason why one couldn't have an order saying there's an opt-out order up until claim size X and an opt-in order above it is because that really is unknowable.
Well, also, never mind the division on claim size, any other attempted division suffers from the failing that Mrs. Justice Falk identifies in paragraph 1651, which is it's all completely arbitrary.
Yeah, absolutely.
So in that example, somebody who's an acquirer of 20,000 vehicles has to opt in. Somebody who's an acquirer of 19,999 gets the benefits of opt out. And exactly the same thing would happen here.
Yeah.
Because in the example of somebody with a claim of 16,000 rather than 15,000 would have to opt in.
Yeah.
On if there's a division of the kind that Mr. Keneally was.
Well, Mr. Keneally was actually suggested it ought to be on turnover, for example, or something like that. Actually, but then it would be a question of on what basis is the turnover stated in the relevant set of accounts? Which are a matter of judgment.
It's a recipe for a nightmare.
Might have had a very bad year or a very good year, or whatever.
Or the year at the time you suffered the loss, or the year at the time you joined the proceedings.
It may be general turnover of which the cartelised section is only a small portion. It may be impossible to know.
Absolutely. Absolutely. And then my final point, and in a sense I've made it already, is that what about the forgotten class with the 3,000s and the 15,000s? So 15,000s he said should opt in. I didn't really understand why, save that they're businesses. And then the 18,000 class members who have the claims of around £3,500, totally missing from Mr. Keneally's submissions. They're not the penumbra, they're not the speculative group that Mr. Ramirez was talking about in his report. They are in the 42,000. They're nearly half of that group, with putative loss, were it to be litigated normally, of around £3,000. No explanation of how they can come at justice at all. And the final point, of course, which is the point which you made to me in opening, one of the first points, is, well, everyone agrees they can't go ahead on an opt-in basis, so doesn't that mean they're impracticable? And again, I come back to that as the most straightforward.
Well, if motive is irrelevant.
Motive is irrelevant.
That must be a complete answer.
That's a complete answer, and in my submission it is.
Well, they say that the cat says that's the wrong question to ask. They say that ostensibly it might suggest it's opt out, but that's the wrong question to ask. You've got to ask why.
Exactly.
They've opted out.
That's right. And I say, A, the cat was wrong, and B, even if it was right, we have the right reasons. So those are my submissions in reply, unless I can be of any further assistance.
Thank you very much.
Thank you. So Mr. Joel to open the carriage appeal, I think.
Yes.
This is what we're calling the cutthroat part of it.
I might duck to the back of the room.
Two of us are old QB hats.
Before I,
Just before you start,
yes,
yes, I suppose we are old QB hacks actually, or KB hacks or whatever. We would be, I think, very much assisted by your identification at an early stage of what the question of law is on this part of the case, whether it's to be viewed as an appeal or as a judicial review, because it seems to us that's an extremely important point. And also part of that, if you like, how this court should approach these sorts of points as a matter of principle, because they seem to be arising, or they certainly are
Yes.
arising, as you probably know, more than once.
yes.
We will another appeal very soon,
Yes.
where the same point arises in a slightly different context.
I'm grateful. Before I do, may I just briefly pick up on my Lord Justice Snowden's request for me to summarise
yes.
how the collusive behaviour consisting of manipulating the fix would have harmed the participants in the interdealer market. One needs to, it's not identified at any sort of single clear place, but he deals with it throughout the report. For example, at 3.26, and he gives a number of illustrations which you may or may not find amusing in a table from 2726 to 2729 and following. And to summarise it, fixing, the cartelists agree to fix the fix, which means to push down, to engage in trades in order to push down the benchmark. And they then themselves attract buy orders, knowing that. Now, the non-cartelist dealers don't know that the fix is rigged and about to fall, so they agreed to trade at that price. And so they then enter into these loss-making trades when the fix is then fixed at the appropriate time. So put another way, the cartelists have positioned themselves to only attract the profit-making trades, and all the loss-making trades will go to the dealers who don't know in advance what the fix is going to be. I hope that assists. That's how we would summarize. Now, on that point and on the question of jurisdiction, which I'll deal with that very shortly. But may I, just before I do, I should make this point. The judgment assesses carriage on a basis that is both obiter and contingent, because as things stand, of course, it's granted both PCRs the right to bring proceedings on an opt-in basis, a notional opt-in basis, and therefore it didn't consider it necessary to decide between them for the purposes of opt-in. So as things currently stand, we're both in this sort of limbo where we have a notional opt-in certification. And the tribunal below did grant permission on carriage, and initially it gave no reasons for that, and reasons were requested by the Evans PCRs, solicitors. And if I can show you the court's explanation, which you'll find in tab 16 of the second volume of the joint core bundle. Yeah.
Yes.
And you'll see that in the third main paragraph, it says the President considers that it is clear from the face of the tribunal's reasoned order that permission to appeal was given in respect of the carriage issue. It should be noted that the issue arises only contingently on the basis of the tribunal's decision. Both the O'Higgins PCR and the Evans PCR can proceed with opt-in collective actions, and they can do so in parallel. It's only if the tribunal's decision on opt-in, opt-out is wrong that the carriage issue arises. In such a case, given the interconnectedness of the discretionary elements in the decision under appeal, the tribunal's contingent decision on carriage would doubtless be reconsidered by the Court of Appeal should the tribunal's decision on opt-out, opt-in, opt-out be varied. and the tribunal's reasoned order does no more than make clear the tribunal's own thinking on the point. Now, as I will show you, the tribunal is plainly right to say that its contingent decision on carriage is inextricably interconnected with its assessment of the main appeal generally, and we will say it stands or falls with that main appeal. But the decision is also vitiated by its own clear errors of law, which I'll come
Why
to.
does the decision as to who's the appropriate class representative become tainted by a decision which on this hypothesis is wrong as to the strength and practicability of
I'll come to that, because one needs to look at the decision in its own terms. And what I'd like to do, if I may, is take you through the judgment first to show you how they come to the decision, and then I'm going to identify the errors of the law. And
But you were assuming this is an appeal, not a JR.
well, on that,
It may not make any difference actually in terms of analysis,
No.
but we've got to get this one right.
no, absolutely. And the test for whether it's an appeal or a JR is that is laid down in paragraph 27 of Lord Justice Patton's judgment in Merritt, which is it going to prevent individual members of the represented class who have suffered loss from obtaining compensation? We both agree that the decision on opt-in, opt-out.
Say that's the test. The test is in section 49(1)(a).
Well, yes, but that is how
Is it as to damages?
As to damages, but that is how that section has now has been up to now anyway interpreted, and the way it's put is if it brings to an end claims of individual members of the represented class who can no longer suffer loss, then that is to be regarded
The
according to
class continue, the members get a claim, the only question is who carries it.
no, and this is that may be so in some circumstances, I accept, but that is not so here, and that is because there's an important difference between the O'Higgins claim and the Evans claim, and so to understand the difference, could I ask you just to look at the Commission decisions, which you'll find in the volume 1 of the supplemental bundle, tab 2.
Just foreshadow the point for us. So what is the difference? Is it the scope of the claim?
It's the scope of the claim, and they are quite radically different, because if you go to volume 1, tab 2, you see in
Still similar subset of the same members, so it may be broader.
it will include a significant number of members that are not in the Evans claim. And the reason if I may show you on the top of page 11, the Commission identifies 3 types of orders characterising the customer-driven trading activity of the participating traders that are pertinent in the present infringement. The first are customer immediate orders, the second are customer conditional orders, and the third are customer orders to execute a trade at a specific rate or fix, benchmark orders. Now, so the infringement constitutes all 3 of these types of orders. And as Mr. Kennelly noted, rightly, at least on the face of the decision, you see the most prominent of these are the benchmark orders.
Yeah.
And the ambit of the class proposed by the O'Higgins PCR includes all 3 types of orders. By contrast, the ambit of the class proposed by Mr. Evans excludes benchmark trades and conditional orders. He proposes only to claim in respect of immediate trades. Now, connected to that is also a difference in methodology, because the O'Higgins PCR proposes to use...
Can you just give us the reference? I don't think we've actually looked closely or specifically at the actual definition of the classes. Can you just give us the references?
We will give you but this is not in dispute, this difference. And the methodology that is adopted in relation to measuring spreads is different in the sense that the Evans PCR proposes only to measure what's called the effective spread, which is the spread at the same point in time. And whereas Professors Breeden and Bernheim propose to measure the realized spread, which is the spread at one time and then slightly thereafter. They explain in their reports that this will capture the effect on spreads of those two other, of collusion on those two other types of orders, the conditional orders and the benchmark orders. And I just give you the reference, or one reference, it's all over the expert reports, but one reference is the third expert report of Professor Bernheim, which you'll find in volume 3 of the supplemental bundle, at paragraphs 30 to 36. He explains the difference. And so for jurisdictional purposes, we just make this point. The effect of O'Higgins including and Evans excluding these two types of trades means that if the Evans claim goes forward, then those potential victims of the cartel that transacted in resting or benchmark orders will have no claims. They will receive no damages. And so it will be the end of the road for any claim for damages for a meaningful part of the proposed class.
So are you saying therefore that we'll both go ahead?
No.
Or just you?
We say just us, and I will come to that. And I will explain why on the tribunal's own logic, on the tribunal's own reasoning, insofar as it's lawful. I will show you. And I make that point on jurisdiction, but I also say that one can equally formulate, even if I'm wrong on jurisdiction, this is a judicial review, the points that I'll be making can be formulated in JR terms as well, as either an error of law.
We're not convinced there's a huge difference between an appeal on law and JR.
No.
I wouldn't try and argue it under one or other.
No.
We have to, for the purpose of judgment, for the purpose of thinking about providing guidance, try and lay down where this is going to be, because it will have procedural implications.
Yes.
But so far as the analysis is concerned, we
very
want
simple.
you to explain to us why there's an error of law. I mean, the tribunal says you're all flipping marvellous. Really, it's almost flip a coin, marginal differences between the two.
Yeah.
So we've got to apply, whether it's an appeal or a JR, we've got
Yes.
to ask ourselves, where have they gone wrong,
Yes.
given that they have,
They've got a wide discretion. In theory, they've got a wide discretion. I fully accept that. Can I take, the easiest way to do this is just to talk you through the judgment, and then I'm gonna, if I may, just come to the points, and it will all fold out quite quickly. Okay. So if you take up the analysis is done in the judgment under the rubric of the authorization condition.
Yep.
And it starts under the authorization condition. And you see that that starts on page 378 of the bundle. And it starts with the PCRs. And you see the conclusion on paragraph 251, page 380. You see Mr. O'Higgins, he's an impressive PCR, and they have no doubt that he's appropriately qualified. And then at 254, they say Mr. Evans, they say like Mr. O'Higgins, we found him to be an impressive PCR, and we have no doubt that he is appropriately qualified. And then how do we choose between them? On C's over page 382, we consider that the PCRs rank equally. So a score draw. Then it turns to the significance of the fact that the O'Higgins PCR is incorporated. And you see that in paragraph 262. And you see that, again, they say this is an entirely neutral factor, entirely neutral matter. So neither is a, and then they go on, page 266, they say neither is a pre-existing body, and that is neutral as well. And in paragraph 271, they then find no conflict of interest. So far, either 10-10 or 0-0, however you want to put it. And then we see they come to the eligibility criteria. And they identify the different classes. And they note that the Evans class is divided into two: those that entered into transactions with the defendants and those that entered into transactions with other dealers. And if you go forward to paragraph 282 on page 388, they say, for present purposes, it seems to us that this factor turns on whether the class can be identified. That we consider is the case so far as each of the formulations of each PCR are concerned. We see no basis for differentiating them. So again, no difference. We then go to paragraph 286, and this now it starts to get a little more interesting, because here they start to talk about what's suitable.
So just to be clear, in terms of the definition of the class members,
Yes.
there's no difference, is that right?
Yes, that's correct. There's no difference that the tribunal finds in the judgment.
But the definition includes the definition of a relevant foreign exchange transaction. And you're saying that so far the exclusion of subcategories 2 and 3.
Yes, they come to that, and I'll show you what they say about that, or they don't say about it. You see in 286, the tribunal states that it regards the term suitable in 79.2 as something that is divorced from the merits of the claim. And we hardly agree with that, and it accords with what Lord Briggs says in Merricks. It's the statutory test, as I'll show you, is which I'll come to this in a moment, it's which is more suitable, which of the two is more suitable. And suitability is not meant to involve an assessment of the merits. And that, unfortunately, is something that they lose sight of, or seem to lose sight of, later in the judgment. Now, at paragraph 287, you see that it notes that as both claims are framed as giving rise to market-wide spread widening and raise common issues, it follows that they meet the relative suitability condition. So that's the condition, is it as compared to individual actions. And in paragraph 289, on 391, you see the last sentence, forgive me, page 391, they say, we conclude that both applications are suitable to proceed as collective actions. And then at 290, it talks about suitable as a relative test. And it says it operates both as an absolute and as a relative criterion. However, that said, we do not consider that this relativity should be used, at least not without explicit consideration, as means of introducing a further merits test through the back door. Well, we certainly agree. We certainly agree with that in principle. But then the tribunal seeks to illustrate the point, and it talks about our argument about the relative widths of the classes defined by the two PCRs. The point that I made to you in relation to jurisdiction, where we said, well, we have the rather obvious advantage of claiming in respect of all three types of trade that were subject to the infringement, rather than just one of them. And it then quotes over the page, on page 393, it notes that the Evans PCR didn't accept this characterization of the width, or rather narrowness, of the classes adopted in the Evans application. Well, that's not quite right, in the sense that I'd be corrected if I'm wrong, but I think that it has always been common ground that they do not include those two types of trade. But it is absolutely right that they seek to make a virtue of that. And then it then quotes a section from the Evans PCR's skeleton argument, headed "Mr. Evans has the better claim," which extols the virtues of their distinction between direct and indirect harm and various other aspects of their approach. And then they cut it off midway, you see on page 394. And they say, we leave the Evans PCR's defense of its classes at this point although we stress that the defence goes on for a number of paragraphs after this, and we mean no discourtesy in cutting short our quotation, which I think means this is all a bit tiresome. But I'm not entirely sure. But it seems to be.
By the time you got to page 159,
Yeah.
I thought it was a bit too.
It probably was. It probably was.
Sorry, maybe it's late in the day and I'm
Yes.
struggling to do this, but isn't the starting point to look at the definition to see whether the actual definition in the pleadings is any different? Why is that not the right starting point for this question? If you say that the certain claims based on certain types of wrongdoing are excluded from the definition of class, is that as a function of the actual class definition in the
Yes, it is.
or
So,
pleading narrowly defined, or is it simply because we're going to have to go and find it in some expert's report somewhere?
no, it's in the pleading, and I've got chapter and verse. I can give it to you for your note if that would assist. So the O'Higgins class definition is at the collective proceedings. It's in the collective proceedings claim form, paragraph 31, and you'll see that it includes all three types of trade. That's at in the key bundle 1, tab 20, pages 1479 to 1483. The Evans definition is summarised at paragraph 72 of their collective proceedings claim form, which is in the key bundle volume 4, tab 4, pages 125 to 126. And if you want the full version, it's in supplemental bundle 1, tab 6, pages 331 to 335. And the way that it works is the Evans prima facie refers to FX spot and FX outright forward transactions, but it then excludes certain excluded transactions, which include at G FX benchmark trades and at H direct limit resting orders. And you can see this clearly in the full version of the Evans class definition, which is at page 333 of the supplemental volume 1 at G and H. So those are the references. So
You're at risk of getting us interested in this point. the issue you've got to grapple with, isn't it the point of 2923,
yes.
293, which is they said it's inappropriate and extremely difficult and inadvisable to assess the relative merits, whether you're right or wrong. I mean, isn't that the point of law that you've got to attack?
Well,
because they're basically saying it's very complex.
Yes,
it's a
yes
question
and
of
no,
discretion.
because actually, if you leave out of account the merits, you will see that on the tribunal's own analysis, the O'Higgins class comes out ahead. And so, even if you take out of account, but I need to.
Would it amount to an error of law? Because they've got to decide.
Yes. Well, the first.
I mean, at the end of the day,
yes.
It seems to us. I mean, it's put in rather Delphic terms, isn't it? But at the end of the day, they seem to have thought that Evans was preferable because of the Class A, Class B division within their theory of harm. That seems to have been and they don't put it like that. They talk about it being better thought through, but
yes.
we can't at the moment see what else they can have meant by that phrase.
Well, there are
right or wrong.
Yes.
We're
So
not
we
right or wrong.
So we say we make a number of. I'll give you if you like maybe a trailer of the points, but I do want to go through the judgment. But our first point is it is an error of what they did in taking that into account was to try and make an evaluation of the strength of the two claims on a very marginal basis, which is not appropriate, not lawful, because suitability is not meant to involve an assessment of the merits.
No,
That
may
is,
be
that is,
right. Let me put this one to you, which we've been trying to get our heads around.
yes.
Whether this is A and or B is fundamental. Certainly, the way it was argued by the respondent is that the A case marginally better than the B case. So it's an issue, it's an important issue, whether it's right or wrong, whether you agree with it or disagree with it. You say it's one market, Evan says it's A and or B. Mr. Kennelly attacks B more than A. It's an issue. So in one sense, it might be wafer thin margins. Their case is more, is better framed to the nature of the litigation as it's going to arise than yours. Whether it's right or wrong is almost impossible to say.
Well,
I'm just wondering if
yes,
that's
no, well, I don't.
just in terms of the framework of the dispute as we can see it
Yeah,
emerging.
well, I don't accept that because our claim also involves classes A and B. We just don't call them A and B. We just include them. They're both in the class.
Absolutely.
And there's no reason, and in your class definition, to distinguish in that way.
As my lord says, it's a wafer thin difference.
Well, yes, but
if that is what they're saying,
it's a
then
well.
they may be, you know, the fact that we might have reached a different conclusion.
No, I accept.
Doesn't matter unless they've made an error of law.
Well, no, but the error.
You say the error of law is they've taken account of the merits.
Yes.
When they shouldn't have done, but I think what my lord's putting to you is actually on analysis that isn't what they've done.
Well, I want to show you what they say, because what they say is it's an analysis of the strength of the claims, and they don't actually say that it's about this class A, class B, and it's really interpolating into the judgment something that one just doesn't find there. It doesn't actually say that. All it says is it's better thought through in some way that is completely unarticulated. So our first point is, and I'll show you, the one thing they do say about it is they refer back to their findings on strength. I'll show you in the relevant. So they do see it as involving an assessment of strength, and that is unlawful. You're not meant, certainly not in a marginal case, to be deciding suitability, relative suitability, on strength. So that is and I will show you that in the relevant paragraph. Secondly, it is in our submission completely tied up with the errors that they make in the judgment, because this is made in a context. This judgment on strength is made in a context in which they have wrongly, in both our submissions, said that both our claims are apt for strikeout, and that again is a point they recognise. So if they are wrong about that, and they have wrongly assessed our claims as strikeable, then that completely infects, both substantively and procedurally, their assessment of the relative strengths. It just logically must do those contexts. And the third point is that it is completely unreasoned. One can interpolate all one likes, and one can speculate, well, it might have been because they thought that we'd adopted collusion on spreads at the last minute. It might be because they liked their methods of their data collection. It might be the Class A's, Class B division. One just doesn't know.
Well, did you ask them to provide reasons?
Well,
if you apply the test in English and memory, that's what you're supposed to do, isn't it? If a proposed appellant thinks that the court or tribunal at first instance hasn't dealt with an issue at all or hasn't dealt with it properly, first thing to do is ask them to clarify it and provide reasons.
Well, we in a sense we both did, because we applied for permission to appeal, and they gave no.
That's not the point. The point is you're arguing before this court that this is an unreasoned decision.
Yes. Well,
did you say to the CAT this is an unreasoned
we said
decision
in our
and therefore you should give permission to appeal?
We did, yes. Yes, in our application, in our grounds of permission to appeal, we said this is an unreasoned decision. That was one of the grounds. They then gave permission.
They didn't deal with that.
They gave no reasons, and then you see they say it's all inextricably linked. When they did give reasons in response to Hausfeld, so they themselves recognise that it's inextricably linked with their decision on the on the main issue of opt-in, opt-out.
Yeah.
So it has to fall, but but I also have some sympathy in saying, well, the fact that you can say that their ultimate conclusion is wrong and that their assessment of strength is wrong. Nevertheless, I don't seek to say that each aspect of the eligibility and authorization which they assess is wrong. Because I accept that we profoundly disagree with a number of these, practically all of these assessments, but we don't disagree on a granular, seek to say that each of these assessments, that Mr. O'Higgins was the same as Mr. Evans, that the experts on the two sides would say, we don't seek to appeal on those points, because we accept that they have a discretion, but we do say that when it comes to the final analysis, it turns from being in our favour to being in their favour on the basis of a completely unreasoned assessment of some idea of strength, which is on a very marginal basis. And that we say must fall. But that is a prelude, and I do want to go through them.
Just, we'll come back to it
Yes.
tomorrow. What I really want to help is what they mean in 389.4. The claims articulated by the Evans PCR have been better thought through and represent a marginally better attempt at capturing an elusive loss. So it's the articulation in the claim of how you capture an elusive loss.
Yes.
And that's why I thought we thought it probably boils down to the difference between Class A and B, and which is the wafer-thin marginal difference they've alighted upon. You're right, they don't say so.
They don't say so, and we don't know. And what they
merits.
It is. If you see, if you look at
In the next sentence, they say, in reaching this conclusion, we are in no sense seeking to apply any kind of merits test. And they can say, we're simply gauging the relative strength.
The strength, and the strength is a reference back.
In the sense 98,
Yes,
which
yes.
is everything under the sun.
No. 98 and following is their assessment of the strength, the meaning of strength in section rule 79.3. It's there. If one goes back to, and this is a straightforward error of law, because we're not in 79, we're in 78. We're in suitability territory. And as Lord Briggs said in Merrick's, the merits come in this regime in two places.
But
not
what's
in
bizarre
three.
about this particular sub-paragraph, like my Lord, I'm
Yes.
troubled by it. Well, this whole paragraph, leave aside whether it's completely unreasoned.
Yes.
Is this odd thing, having said what they say in the first sentence of 5, and then said something which, at least on one view, looks completely inconsistent in the second sentence of 5. What they then say in the third sentence, to put the point differently, we consider the essential question to ask is which applicant will better serve the interests of the victims that comprise the classes, seems to be a point that isn't a merits point, isn't a strength point at all. So they seem to be saying, well, another way of putting it is something that isn't. We just think Evans will do a better job for whatever reason.
And this won't do. This is not, one can't, it's just not good enough, actually. You've got, and it's not good enough to either side, because you've got Professor Rime, you've got Mr. Ramirez, you've got Professor Bernheim, you've got Professor Breeden. They articulate their differences and over expert report after expert report. And one has to go back to them and they say, well, the tribunal found that they are better. Well, why? I have no idea. That isn't how a judgment in this jurisdiction is meant to be reasoned.
You might have been tactically better off pooling your resources and splitting the result.
That may be the case.
On one view, you've provided Mr. Kennelly with quite a lot of ammunition.
That may be the case. And it's a point I that's a point I would come on.
Anyway, that's I think more than enough for one day. What this is demonstrated is that if you sit an extra 45 minutes. It's about the limit, I think, for everybody, certainly for the court, and I suspect for everybody in the courtroom as well. We'll say 10:30 in the morning. Thank you very much.
All right.